Hello, welcome to this Summer of Law webinar. My name's Professor Lydia Hayes. I'm a Professor of Employment Law here at Kent Law School, and I'm head of the law school. I'll let my colleague Diamond introduce herself.
Hello, good afternoon. I'm Professor Hayes and Ashiagbor, and I'm also a professor in Kent Law School, and my areas of teaching and research are European Union law, employment and equality law, and I also oversee the PhD programme.
So this is the last in the series of Summer of Law for 2020. And what we've covered so far in these webinars has produced a whole playlist on YouTube in the Kent Law School channel that you can go and look at. So some of you will have been following us throughout the whole of the summer in this series. Others will be coming to it perhaps new today. So if you want to go and have a look, we've got topics in there like what is a criminal trial, about property law and the toppling of slaver statues. There's a webinar about the functions of different courts and what they do. The most recent has been about argumentation techniques in law. It's a really good resource. Diamond's going to load up some slides now so we can introduce our topic for today, which is about what is a critical legal education. And we are going to run through the structure of the session now. Diamond, if you could move a slide on, please. Thank you. So first of all, we're going to think about what the purpose of a legal education is and ask you about that too. Then we're going to be looking at the traditional content of a legal education before we move on to think about what difference does it make being critical? What does that word contribute to the study of law and legal education? And then we're going to make it very practical and look at some examples of critical approaches to law that have been taken in legal cases. And then we're going to move on and ask you to help us brainstorm some ideas about critical thinking and how you can think critically through a scenario that we're going to provide, which is in an employment law situation. And we'd very much like it if you got involved in the discussion. We'd like you to share your thoughts and views in the chat section of Zoom. And just so that you know, when you put comments in or answer questions in the chat, it's only Diamond and I that can see what you've written, so you don't need to feel embarrassed or shy. There are no wrong answers. We are genuinely interested in your views. And if we discuss what you've written, don't worry, we won't be using your name. So with that, can we move on? We want to talk about initially what is a legal education for, and there's some pictures on the screen here of kind of the popular face of law on the TV. And very often law is represented through gruesome crimes, and the idea of the historic defense of the innocent is very connected to locations of courtrooms and the operations of the police. So I'd be interested if you could put in the chat what your legal education is for. If you're going to study law, what is your education for? What are you doing it for? What's your objective going to be? And while you're thinking about your answer to that, I'd like to ask Diamond. Diamond, what was your legal education for? So when you became an undergraduate, what were you thinking of? What did you think its purpose would be?
Well, it started even in the application in the UCAS form. We had the same application, and then I remember very clearly what I said, which was I was interested in law and its relationship to society, but I also very much thought, the reason I was going to do law in university was so I could go and be a lawyer, a solicitor or a barrister, because I was interested in what we call civil liberties, what we probably call human rights now. So it's very much, and I'd also done 1 week in work experience at school in a local solicitor's firm. So it's very much what I thought doing a law degree was all about.
Yes. Oh, there's some really interesting answers coming in. Clearly, we've got an ambitious group of participants and people that are really concerned about the importance of being able to change the world. So we've got here ideas about being a voice for people who aren't fairly treated by the system, whatever that might be. Somebody here who's got ambitions to work for the UN, wanting people to help people, getting rid of victimization. Another person here says about promoting equality and justice. Another person here says, I'm hoping to become a corporate solicitor. I want to be a barrister. I want to learn about legislation. So lots of really interesting ambitions that people have in their study for law. It's clear that a legal education is strongly linked to the idea that law is a vocation, it's a calling, and it's a career. And this is a career that offers the opportunity to help others or to secure like an elusive thing that we call justice, to deter wrongdoing. But if learning about law is a vocational endeavour, why is it taught in university? Why is it taught as a degree? That's the next part of our discussion here. The fact that law is not only a university subject, but more importantly, that legal education is part of the foundation of universities across Europe, gives us a clue about the significance of legal education beyond the vocational focus. So my next question for participants is, how old do you think the longest established university in the world is? So one that's still going, but was established quite a while back. How old do you think that university might be? I've had an answer here which is bang on the money. I've got other answers which say 130 years old, 120 years old, 500 years old. Quite a few people have put. Somebody here has said 900 years old, and that's a pretty good guess because the oldest university is the University of Bologna in Italy, which is 932 years old. And law has been taught in universities for a very long time because law is foundational to the creation of modern societies. As people grouped together to establish towns and cities, they needed rules to establish how they were going to live together. And they engaged in trade and they set up businesses and they needed rules to govern that trade and systems in place to resolve disputes about money. And a further function of law was to categorize and organize society in terms of property ownership and freedom of movement, things that were available to some people according to the rules and not to others. The provision of legal education was a foundational purpose of the university at Bologna, and for almost 1,000 years, universities have had at their core a group of people who hold a very special place in society. These people, these citizens, the position of a lawyer or a legal scholar. Now, why is this position so important? Universities educated a class of people who would understand the rules, and they would apply the rules and develop the rules, test the rules, judge behavior, events and transactions according to those rules. And because law was based on a distinct and tailor-made set of concepts and phrases, it required training in a university to train and educate a class of scholars who could get to grips with the specialism, who could understand the reasoning of law, people who could know the intricacies and act as advisors to those who wanted to invoke the rules in pursuit of a set objective. And mainly, those people were those with high social status and wealth. Now, Diamond, you have some quotes and insights about why law is still taught in universities.
So what's happened is that initially, even after the foundation of the University of Bologna, in many parts of the world, in the UK, becoming a lawyer was done through an apprenticeship or training on the job. But that was considered to be too narrow. And even so, from the 17th century onwards, this idea of apprenticeship in barristers' chambers or law firms, which involved observing the work of a solicitor before trying your own hand, it just became understood that that was too narrow, it was too inadequate in its scope, this apprenticeship model. And so even as recently as 25 years ago, the most senior government officer overseeing the legal system, the Lord Chancellor, established a committee, the Vice Chancellor's Committee on Legal Education, which came up with a report in 1996, which was accepted by almost every university and every law school, that a law degree should stand as an independent liberal education in the discipline of law, not tied to a specific vocation. So it's not just about training people to be solicitors and barristers, because an apprenticeship gives students a practical understanding of law, but not really understanding of the principles behind the rules. So students should study at university law school where they can talk the broader discipline. So it's not just about what the law is, but it's also about why. What's the social or economic or political reason behind the rules? So that's the really strong underlying principle across university law schools, that law is not just a vocational subject, but it's an independent liberal education.
Thanks, Diamond. So let's just briefly cover what a traditional legal education covers. And when I talk about traditional legal education, the image there is the A-level law syllabus through to the content of a traditional law degree. So a traditional legal education focuses on the nuts and bolts of several branches of law. So within that system of rules and concepts and reasoning, there are distinct subsystems, and these are applied in respective distinct social and economic relations, such as land law and criminal law and contract law, and students are traditionally taught the basic framework of these subsystems. And they're taught how to apply the rules in ways that frame social questions as legal questions. And so that those social questions, like should a person be punished for a particular type of behavior, or should a person be removed from a particular place, that those questions can be answered in law, that they receive legal answers. And yet these elements that comprise a traditional legal education in a degree also make up the content of a critical legal education like the one at Kent. So let's now look at the difference that the word critical makes. What do you think, participants, what do you think that the word critical means? I'd be interested in your understanding of that phrase, because if a person is described as a critical person, it's often not a compliment. And if comments are received by a person as critical comments, then we might assume that the person feels discouraged or offended. But that's not what we mean when we talk about a critical legal education. As somebody has very rightly put here, being critical is about asking questions. Being curious, that's a brilliant word. It's about analysis. It's intellectual. It's scrutinizing is another great word that we've got here. For me, it aligns more closely with the part of the dictionary definition, which is to do with judging or questioning or considering whether the law is working well. And this begins to unpeel the first layer of an onion, really, in terms of a critical legal education, because if you're going to ask, is the law working well, you need to have an understanding and knowledge of what the law is trying to achieve, and you need an opinion as to whether you think that's what the law ought to achieve. And you need to be able to identify a difference between what the law tries to do and what it actually does. You need to think about what it ought to do. And you need to ask questions about why those differences exist. Why is it that when social questions are answered with legal answers, there might be a difference between the effect that the law has and the effect it's supposed to have, and the effect that you think the law should have? So being critical in the context of a critical legal education isn't negative about the law. It's actually very optimistic and engaging and hopeful. It's about considering how the power of law could be put to the most beneficial of uses. So this special class of citizens, those that are taught and educated as lawyers, through a critical legal education, are able to have something extra, something additional, not just to know the law, but to have an opinion about it, to think effectively as a person trained in legal reasoning, and to think critically in the spirit of hope about how the law could be better. And because law is steeped in tradition, we shouldn't assume that the law stands completely still. So Diamond now has some examples of innovative approaches to law and legal cases in the court, where we can see that although there may be the possibility of the historic tendencies of law, the precedent basis of decision making, to perpetuate historic injustices, having legal scholars and legal practitioners who are able to think critically provides an important avenue for improving the fit between the law and the society that the law serves. So over to you, Diamond.
Thank you, Lydia. So I want to pick up on Lydia's point about the law being steeped in tradition, but society is always changing. And so that means sometimes a particular formulation of the legal rules can preserve, as it were, in aspect, can preserve a sort of, in a rigid way, a very old or out-of-date understanding of social relations. And so the first example I'm going to give is the criminal law of provocation, and to think about what difference a critical perspective or a feminist perspective might make. In the criminal law of murder, there are two partial defences, and the defences are partial in that if the court accepts the defence you've put forward of provocation or diminished responsibility, it doesn't mean that you are not guilty of killing somebody. You're still guilty of homicide, but the effect of the partial defence is to reduce what would have been a mandatory sentence of life for murder. So these defences perform a function which excuses part of the wrong. So it results in acquittal conviction for manslaughter. It does acknowledge a life has been lost, but it means that you didn't commit murder. Now, the provocation defence emerged originally way back in the 17th and 18th century, and has developed at a time when if you committed murder, that was punishable by death. And a concession to human frailty was you could excuse a person for loss of control, loss of self-control. So the old categories of the conduct which could amount to being provoked were if, for example, a friend or relative were attacked, or if, for example, a man saw another man committing adultery with his wife. So those are the kind of classic examples which you could say you were provoked to commit murder. And in 1957, the Homicide Act sort of codified that common law into statute, and it pretty much preserved that idea, but it said also that words can constitute provocation. But it required you to have a loss of control, which was sudden and temporary, and that's what led you to commit the act which results in someone's death. And this was argued to favour male defendants over female defendants, given the way that it's more likely that men will react to a provocative situation by exhibiting hot rage, and that might be contrasted with what's more likely to be a female reaction, which might be more slow burn or perhaps fear. So the provocation defence envisages reacting with anger, but it doesn't envisage reacting from fear. So, for example, women who are subject to abusive conduct in a relationship over a long period of time, that might accumulate to a stage where they ultimately lose control, but they're not going to be able to rely on the provocation defense. And this changed in the case of Karanjit Ahluwalia, who's on the left there in the yellow shirt with Pragna Patel in the grey shirt, and Pragna Patel was her solicitor from a women's rights organisation called Southall Black Sisters. So her photograph in 2019 to mark several years after her murder conviction was successfully quashed in 1992. So Karanjit Ahluwalia gave up studying law in India to move to England with her husband Deepak in 1979. She endured a decade of violence and rape and sexual abuse and being kept in the house from a controlling husband who treated her like a slave. When she could stand it no longer, she set fire to his bedclothes while he slept. She didn't intend to kill him, but 10 days later, he died and she was charged with murder. Her plea was that it was manslaughter, not murder, because of provocation, but that was rejected. The jury found her guilty of murder and she was sentenced to life in prison. Her plea of provocation failed because the law demanded an immediate incident of provocation that acts as a trigger to the loss of self-control. In her case, a few hours had elapsed between her husband's last attack and then her retaliating. And those few hours meant that she was considered to have cooled down, and so her defense, she wasn't able to rely on defense of provocation. Her case was supported by this campaigning group, Southall Black Sisters, but also supported by the writings of legal academics in critical law schools such as Kent Law School. Southall Black Sisters and an organisation called Justice for Women won appeal in 1992 on the grounds that expert evidence and psychiatric reports had not been presented at original trial. And the appeal before the Court of Appeal considered new evidence about her experiences of domestic violence and its impact on Karanjit and on battered women in general, and that the trial judge had misdirected the jury on the criminal law of provocation. So the legal team put forward new defences of provocation and diminished responsibility. So what happened in this case? Although her appeal was successful, the appeal was successful on the basis of diminished responsibility. The Court of Appeal did accept that this idea of sudden and temporary loss of self-control in provocation excluded the experiences of battered women. It did recognise that, but it said in the fact of this case, we're going to allow her appeal on the basis of diminished responsibility. What that did though, that her case and others prompted a change in the law. So in 2010, the law of murder in England and Wales was changed as a result of cases like hers and other women's. There's what I call the Law Commission, whose job it is to look at the law over the past 10, 20, 50 years and make proposals for reform. And the government enacted these proposals in the Coroners and Justice Act in 2009. And it abolished the law of provocation in recognition of the fact that it was male biased and outdated, and introduced a new partial defence to murder known as loss of control. So much simpler. And so defendants have to meet these requirements that they acted either in fear of serious violence being done to them, or things were said or done that constituted an extremely grave and caused the defendant to have a justifiable sense of harm being done. So this requirement of suddenness is removed, and it makes it easier for women who've been physically and emotionally abused to show their acts as a result of slow burn and fear. At the same time, factors such as sexual infidelity, factors such as a married man seeing his wife being unfaithful, that was removed as a ground for provocation defence. It could no longer be used to reduce murder to manslaughter. So what lawyers such as Pragna Patel of Southall Black Sisters and legal academics teaching places like Kent Law School say is, the standards of male behaviour from the 17th and 18th centuries became entrenched in the law and didn't allow for examining abusive, coercive, controlling, constraining contexts of women who kill in these contexts. So it didn't allow for social, cultural, economic reasons to allow, which might be a partial defence to murder. And also, until recently, the law was silent on the fact that non-physical abuse can also cause harm. So the law's also been changed to allow for what's called coercive and controlling behaviour to be categorised as abuse, which might also allow one to bring that defence of loss of control. that's the first example. I wonder if anyone's got any sort of comments that Lydia can see the comments in the chat. I can't because I'm sharing the screen. So I was wondering if there are any sort of responses or reactions to that example of the difference which a critical or feminist perspective might make to criminal law.
Well, if people would like to put in their comments and questions, would you like to introduce the second example, Diane?
Yeah.
Then we could take the comments as a whole.
So the second example is about different ways in which law may regulate human use of the natural world. And it touches on the different ways in which social questions can be framed as legal questions. So take, for example, human-made and human-made environmental problems such as, there's so many to choose from. I'm going to choose the example of overfishing in a lake or the sea. So let's say we acknowledge, according to sort of scientists and fisheries experts, that if we carry on allowing large commercial fishing boats to trawl the lake beds or to trawl the ocean beds, fish supplies will disappear because there won't be time for the fish to breed, for example, or we're polluting the ocean in such a way through very large trawlers polluting with oil residues. Okay, so that's a human-made environmental problem such as overfishing. What are the legal mechanisms to ensure the environment is protected? The orthodox or classical legal approach to protecting the environment is that we use statutes or court cases to protect the environment through a claim based on rules in specific areas such as property law. So a farmer might say, I own this piece of land, so you can't trespass on it. You can't trample the newly sown seed. So that's one way of using property law to protect the environment. Another way is you might use what's known as tort law, which is you're saying, even if the ownership of a particular area is in doubt, if somebody is causing damage or some sort of mischief, that could also be an area of law which is used to protect the environment. Or you might use international law to protect the environment. You might say the seas within 5 miles of the coast of the United Kingdom, only UK registered fishing boats can fish there. But what if you get further into the Atlantic and that part of the sea doesn't belong to any country? Then international law might step in, and you might have agreements between different countries to regulate what kind of commercial fishing can happen. And that's the sort of thing that happens in the context such as the European Union, that the 7 member states of the European Union regulate through international agreements over fishing. But a completely different approach, so this is the question of different ways in which law can regulate social questions, has been pioneered in a number of countries. In particular, I'm going to pick an example from New Zealand, but also in India, Australia, Ecuador, Bolivia. So this example comes from New Zealand. And so this photograph is of a river flowing through the Wanguni National Park in North Island, New Zealand. In 2017, the New Zealand Parliament passed a historic statute to recognise the special relationship between the Wanguni River and the people whose ancestors lived in that area for centuries. This act, the Te Awa Tupua, the Wangani River Claim Settlement Act, dictates that the Wangani River is a living entity and a legal person with rights that can be judicially enforced. The enforcement is done by human guardians in a court. So what that does is to recognise the river is an entity that's indivisible from the people, the various Maori kinship groupings with historic and religious connections to the river. And so legal personhood is granted to the river. And that doesn't happen overnight. It happened as a result of activism and arguments in Maori legal thought, going back as far as the 1880s. And so what you had here is, in contrast to the dominant legal approach of protecting the river through, for example, property law, this act confers legal personality on the river. The river is a legal person, subject to legal rights. It actually also subject to duties dictated by law, but those duties are carried out by the human guardians. The duties would be about maintaining water purity. So to provide the rivers long-term protection and restoration by making a person in the eyes of the law with the same rights and responsibilities as a human person. And that act was widely reported internationally. So what it does, and this is where the kind of a critical approach comes in, it's recognizing, it's bringing together different ways of thinking about the law. Because in common law, which New Zealand's legal system is very similar to England, Wales, and its basis is a common law system, it's not unusual for governments of common law systems to give legal recognition to non-human entities. That's actually seems to be quite a normal thing to do. For example, a corporation. So Barclays Bank is public limited corporation, and that means it can sue and be sued, it can own property. Common law also gives legal identity to charities, to trusts, to societies like a tennis club. They can own land. So what this statute in New Zealand did is to combine a long-standing idea from common law that it's a fiction, we've made it up, but we're codifying a legal fiction that a company can be a person. It's combining that with a long-standing idea from Maori or indigenous legal thinking that human beings have a symbiotic relationship with the natural world, and the river, the mountain, doesn't belong to the human beings belong to the river and the mountains. So that new arrangement, the advantage of that new legal approach, it creates a new legal person with the necessary rights to protect the environment, but not from the point of view of what can humans get from the river, but more that the river has a right to exist. So that's my second example of how a critical approach may change how we translate social questions into legal forms.
Thanks, Diamond. We've got loads of comments in the chat,
Great.
and unfortunately we haven't got time to deal with them all, but people are asking questions about the idea of fear, how it plays into notions of whether or not action is premeditated, notions of provocation being changed from within cases heard in the courts, then leading to changes in legislation. People have made comments about the idea of a river having rights is very interesting, that it offers a way for protection of the environment. Somebody here saying that law is maybe seeking to preserve existing relationships and processes of power, but as social consciousness develops, that constellation of power that underpins the law changes because those relationships change. And I think that's a really important point when we think about how critical legal approaches to law can change law. Could we move on to the next slide, please, Diamond? Is a critical legal education a new idea? No, it's not. Kent Law School was founded in the late 1960s, and at that time was populated by academics who were training future generations of lawyers who were thinking critically about how legal education might change. Their legal education, those traditions owe much to feminist and Marxist thinkers who were thinking critically, who were prepared to think differently, and they considered themselves to be living in a time where it was ripe for change, a time when campaigners in different social movements could be listened to, should be listened to, and when scholars of law were looking into understandings of society that were developed in other parts of the university: history, philosophy, industrial relations, cultural studies. So a critical legal education was built on the idea that law students benefit from understanding society based on knowledge that's also developed elsewhere in the university. And I've got two quotes here from critical legal educators from the 1980s. First off is Alan Hunt, who talked about the importance of critical legal studies as a project marked by the idea of diversity. So to think differently was critical to being able to think diversely, because it was a process of imagination about how law might look from different perspectives, how law might influence and affect other people's lives and livelihoods. And so it required a certain degree and capacity for intellectual experimentation. And then I have here a book by Duncan Kennedy from 1983 called Legal Education and the Reproduction of Hierarchy, something that he later described as his radical, egalitarian, alternative vision of what legal education should become, and a strategy for struggle in that direction. So if we move on to think about how we teach critical legal education at Kent, it's fair to say that the times that we are living in are times where it may be arguable that the time is ripe for questioning. So the next generation of lawyers will need to be equipped to respond effectively in light of social problems and questions like those raised by the global pandemic, those raised by the Black Lives Matters movement, the social questions and problems that are associated with climate change and inequalities around the world that are forcing people to migrate. And through every part of the programme, we guide students to think critically. And importantly and distinctively, we begin Kent students to think critically from day one of their studies. The first module in the study of law at Kent is called Critical Introduction to Law. And the education in that module is built around the idea expressed in this quote. It attempts to question common sense presumptions or authoritative pronouncements, such as how people would react in situations where they may take somebody else's life, as an example, to come back to the things you were talking about, Diamond. So to question those common sense assumptions about law, and even the relationship between law and society, maybe even law and the environment. And even before the student has begun to think like a lawyer, in inverted commas, something that a traditional legal education teaches students to do. And I've got a quote here from the convener, Dr. Steve Pethek from Kent, who says the overarching point of his module is that running throughout everything, law and power are absolutely bound together. And so that's why the module starts with looking at the way that law was used in Nazi Germany to justify the perpetration of atrocities, to look at the Nuremberg trials, to look at law being used for a very different purpose, to hold people to account for their behaviour, and also to introduce the idea of law at a national and international level, and to think about what law actually is and what it means in terms of its relation to justice. And students are then drawn to look at law through a variety of different lenses. A feminist lens, to look at law through the lens of race, to explore how law can be used as a tool of racial hierarchy, as well as a way in which it can be used as a tool for racial justice. Lectures also explore how people access the law, who gets to access the law. And if access to the law is limited, then how that shapes and influences the way that the law develops. And central to this is a consideration of law and money and law in a globalized world. And this is our critical introduction to law at Kent. And it's a module that builds on the radical thought of scholars who came before us. So what we're going to do now is to involve you in an activity about some brainstorming. Diamond and I are going to ask you to think critically about a scenario in an employment setting, and to ask you to think about what the social problem is here, what the legal problem might be, so how this social problem then looks through the lens of law, what is it as a legal problem, and then start to critique how law might look for an answer to that problem, and how we might critique law and think critically about law on that basis. So Diamond, could you run us through the scenario, please?
Okay, so this actually is based on, it's drawn from a scenario we sometimes refer to them as problem questions I've used in teaching in employment law, labour law course when we come to the week where we're looking at equality in the workplace. So as you can see here, the set out the facts, the main protagonist, Amma, African descent. Amma is actually a Ghanaian name. It was a trainee accountant. She was the first member of an ethnic minority community to be given one of the traineeships in this firm. All the other trainees taken on were white, although there was a broadly even gender mix. Currently, the only non-white staff in this accountancy firm are employed as secretaries, catering staff, and cleaners. So there were no other ethnic minority accountants or trainee accountants. So 1 year probation, and Amma's contract was terminated. The other, only 2 trainees were terminated. Okay, she was one of them. She was told her technical abilities were good, very strong, but there were concerns that her presentation, the way she presented herself, and her people skills were not good enough. In particular, some colleagues had said, colleagues and clients actually came across as too serious and too intense. And the advice from the accountancy firm was that she needed to lighten up. She needed to learn that while success was important, other things mattered. And she needed to be able to have good contacts from outside of work, to be sociable. So in order to attract new clients to the accountancy firm, she needed to be able to have contacts of potential clients and to be able to be sort of socializing with these potential clients. So those are the reasons she was given for why her probation was ended whilst the other trainees were kept on.
So the question to you, the participants, is what do you think the problem is here? What's the social problem that's being outlined in this question? What is the problem in terms of what's happened? Just waiting for your responses. Okay, so the problem is that Amma has lost her job and her income. A problem as to whether she may have been treated fairly or not. Prejudice towards Black minorities. Race discrimination at work. Lack of understanding about how other people from other cultures maintain relationships. How do you draw a line between professional and social interaction with clients? Unconscious bias. Was there a difference in the way that her colleagues treated her? So we can immediately see that people have gone to the heart of the question about discrimination and race in this this scenario, Diamond. What do you think that the legal framing, you know, what are the sorts of things that the law would be interested, Diamond, about this situation?
Well, the starting point is what kind of legal issue or legal harm or legal wrong has been done, and the main one is she's lost her job, she's being dismissed, and that treatment is different from other employees, and there's also a difference in race. So the detriment she's been subject to, one legal question that comes up immediately is that treatment of her, which is less favourable, is it because of her race? Is it on grounds of race? Would it amount to a claim that the law describes as direct discrimination, where somebody is treated less favourably because they're because of their race or ethnic origin or national origin? Now, this area of direct race discrimination, it's notoriously difficult to prove. It's very rare that people admit, even to themselves, that race or another equality law characteristics such as sex or religion is the real reason they've made a decision, especially a negative decision like dismissing somebody. But that's the starting point. So what you've identified, the sort of social issues. The legal question is, is her dismissal, is a refusal to keep her on after probation, an act of direct discrimination? And you're going to need more facts, really, which is...
Diamond, can I just ask, we could ask the participants how they think that we might be able to establish whether or not her treatment is a matter to do with her race. So participants, if you could communicate with us and put in the chat what you think the difficulties might be with trying to establish that in law. Okay, so I've got one person saying, because the co-workers, it's not a diverse workplace, then co-workers wouldn't necessarily be open-minded to different different ways that people from different cultures interact. Asking whether we could ask colleagues how Amma was doing her work, whether she was a good colleague. Somebody's asking about whether she was given warnings about her serious attitude. Needing to look at the characteristics of other trainees who may have been fired. And that might lead us on to the second person who's been fired in this scenario. I think that's on the next slide.
Okay.
This is a situation to do with Bailey. And Bailey was told that her style of dress and her general demeanour were too showy. Apparently, colleagues and clients found her embarrassing. Bailey was said to be too fashion conscious ever to fit into a traditional accountancy firm like Lost & Sons. And the partners laughingly suggested that she should pursue her dance hobby as a career. Now, if Amma was the only minority ethnic person at the workplace, we can assume that Bailey was white. What do you think the issues here are, Diamond? How do you think that the law would look at this situation and perhaps connect it to what's going on with Amma too?
So the two are connected in an interesting way, because the firm is asking trainees to meet criteria where it's not necessarily being explicit, and the lack of being clear about either you can't be too serious, but you can't be too fashionable either. And that is problematic, but on top of that, it might also, in some circumstances, amount to discrimination. The fuzziness, the assumption that everyone is meant to know exactly what the unwritten rules are. And the problem with unwritten rules is they can amount to indirect discrimination, because, so we're told that Amma is the first employee from a minority ethnic group. And this is something that we don't have the facts for, but this is a kind of issue that you might bring up in a discrimination claim. If you're saying that you have to have contacts in the business world, that might seem neutral. But the non-work contracts and that kind of social life might disproportionately exclude people from certain kinds of backgrounds. It might disproportionately exclude people from lower socioeconomic backgrounds. And that, in this country, there's an overlap, because the general discrimination in British society means that people from minority ethnic groups are overrepresented in lower socioeconomic classes and underrepresented in, for example, elite educational establishments where they might be able to get those kinds of contacts for future clients. So the unwritten rules that you need to pass before you can get kept on a partial probation could amount to indirect discrimination on grounds of race. But at the same time, the rules that seem to have been, that Bailey seems to have not met, they could be seen to be a form of discrimination on grounds of socioeconomic status. The issue with that is Parliament has debated including discrimination on grounds of socioeconomic status in the list or in the equality legislation, but that in the end wasn't included. But Bailey's situation offers an important comparison with Amma's situation, because it seems to be set up an impossible benchmark or criteria for people from non-traditional backgrounds to meet.
Thanks, Diamond. A question that's come in is about whether a company should be expected to have a dress code. And if there was a dress code and Bailey breached the dress code, does that mean that there would be no discrimination issue?
That's a really good question. Over the years, as you can imagine, that issue has come before the courts, and the statute doesn't specifically say you can have a dress code, you can't. So it's really a way of looking at it is, if you impose a dress code that says, for example, men must wear trousers, women must wear knee-length skirts and high heels, the company might say, we want to present a professional image to our clients. But the employees might say, why does that have to be done on the basis of very strict gender dress codes, for example, or that if you prevent employees from wearing crosses and skull caps or veils, okay, so that might also that would be discriminatory, or it will prevent people from manifesting their religion. So what tends to happen is courts will look at the balance of what's the employer's objective. Is there a legitimate objective the employer is going for? Be presenting a professional face to customers, or be neutral in terms of religion. That might be the objective reason. But is that objective reason outweighed by the discriminatory impact? So here, in the case of Bailey and the dress code, well, we don't know if there is a dress code. It would be reasonable for an employer to say smart dress, but it's becoming much more of a legal issue to define smart dress and presentation in a way which reinforces a very narrow understanding. So for example, if you said you can have long hair only if you're a woman, or you can have long hair, but it mustn't be dreadlocks. Mm-hmm. Okay, so this is going to be having a different impact on different groups. For example, a man who wants to have long hair, or somebody who from a Rasta tradition and wants to have their hair in dreadlocks.
So this is showing how the law of indirect discrimination is developing in response to critical examinations of how company policies, for example, may be indirectly discriminatory against particular groups in society, and that the law is developing in terms of how the courts understand those issues. If we were to think critically about what, if we go back to the situation of Amma, Diamond, about what Amma's prospects might be in terms of, you know, if she was to try to claim race discrimination for her treatment, for the loss of her job, if she was to say, well, nobody else has been told to lighten up, and I think that that's based on a lack of understanding of me, then what kind of difficulties might she face in terms of establishing that claim, or finding it difficult to get a timely or satisfactory resolution to this problem that she's got of the loss of her job? One of the things that I find very interesting in these kind of cases is just how long it takes for people to be able to establish a claim and to achieve justice, and the limitations of the law in terms of dealing with the immediacy of some people's difficulties in a workplace scenario. It's not really likely that she would be able to get her job back, is it? Okay, Diamond, I think maybe your sound has gone.
No, yes. So the thing about the way the equality law is structured, and much of employment law, is that it often requires an individual to bring a claim, and whether if they're still working, then that's very, very difficult, because you'll seem to be doing something against the employer. But even if you've lost your job, as in the case of losing a job from an accountancy firm, there's a real stigma of being seen to be somebody who brings a former employer to court. And that could cast a real shadow over any future careers she might want to have in the accountancy industry. So it's not just that it's difficult gathering the facts. So if you could have some sort of, I know, a tape recording of one of the partners in the accountancy firm actually saying, we don't want to employ any black women, but you don't get that sort of evidence. So that will be difficult in itself. But also, as Lydia said, the practicalities of bringing a case which is going to take quite a long time, and the resolution or the remedy, if successful, typically the law gives a rather sort of a proxy, a crude compensation. And the compensation is in terms of money. It's rarely in terms of something like getting your job back. That's very, very rare. So what you get if you're successful, which is, you know, it's quite rare, is a monetary compensation to put you in a position as if you hadn't been discriminated against, but it's never going to be a perfect putting the person back in that position, because that would mean that they would never have been discriminated against in the first place and never been dismissed.
Yes. There's some really interesting comments in the chat, Diamond. It's raised a lot of issues to do with how to prove indirect discrimination, about how we know whether race is used as an excuse in terms of protecting people from dismissal, issues to do with the fact that it's both women who were fired in this case, about the way in which this kind of example might influence how companies treat employees, that they may think twice about the way that they deal with people, asking about things like how quickly are Black and ethnic minority employees churned out of companies compared to white colleagues, questions about the whole basis of comparison really between men and women and people from ethnic minority backgrounds and white people. Some really interesting questions about the law and its effectiveness that require critical thinking in order to find a resolution. So we've reached the end of our time. It's been fascinating, and thank you all so very much for your contribution and involvement to this. I've just got two quotes, if you can find them on the cheers, Diamond, thank you. So this is just about the benefits of a critical legal education, according to two of our alumni from Kent. So the first quote is from Alexander Wright, who's a solicitor, who says that he got top A levels, but he never wanted to go to Oxbridge. And he wanted to come to Kent because of being able to learn what the law is and why the law is the way it is, and to ask, is it good enough? Which is a really important question for our students at Kent. And the second quote is from Cyrus Larizade, who's a QC, who says, the law has never stood still for me, that he's tried to push boundaries, he thinks outside the box. He tries to provide creative solutions to situations which may otherwise seem hopeless and intractable. And he puts that down to his education, his critical legal education at Kent. So I'd just like to conclude by thanking everybody for participating. And if you want to learn more about what we do at Kent, more about critical legal education and more about legal resources where you can find out more, there's a great resource that's on our website for undergraduates. You don't have to be a student at Kent to access this. And it's a document called Hello KLS 2020. And there's loads of really accessible resources that I'm sure that you will find fascinating. So that's the end of the Summer of Law. Thank you so much for joining us. It's been really enjoyable. And I know that all of the colleagues who've taken part in this series have really got an awful lot out of the interaction that we've had during the lockdown on Zoom. I've got a question here about where to find the previous videos. You can find them on YouTube. If you look for the Kent Law School channel on YouTube, it's a special playlist. Okay, thank you. No, that's fine. Thanks, Diamond. And thank you all very much. Goodbye.
Bye-bye. Thank you for coming.